the effect of the law is that if you know about it, you're supposed to disclose it. It's not whether or not you think, the seller, that it may cause a problem. If the facts in and of themselves point to a recurring problem, then you have to disclose. And I would close with this. This court in Sink versus Florida Community Service, Corporal Wallen County, pointed out, and I believe, Your Honor, Judge Browning wrote the case, that evidence of other incidents known to the defendants are also relevant in establishing the defendant's knowledge of the defects. You don't just look to what the defendants themselves say. And basically what the trial court did below is minimize the effects based on what the defendants thought. But as the court said in Dorton, it is whether the facts in and of themselves materially affect the value of the property that creates the duty to disclose. And it's our contention that on this record, there were clearly facts. And in the brief, we set out all of the types of leaks that must be disclosed. I think there are probably about 13 or 14 different types that are itemized there. And it's our contention that the court erred in applying the law to the overall effect of the case, as in the Holland versus Gray.
20 seconds.
Thank you.
May it please the court? My name is Kristen Hewell. I represent the appellees, Dr. and Mrs. Michael Karsten. The Karstens request this court affirm the trial court's order in which the court, acting as both the trier of fact and law, concluded, based on the evidence and the testimony presented during the course of a 4.5-day trial, there was insufficient evidence to support a claim of nondisclosure under Johnson versus Davis. Although the appellant has couched this appeal as being a legal issue, the grounds upon which the appellant seeks review are factual in nature. And as you all well know, the review of the trial court's findings of fact are limited to determining whether the findings and conclusions were supported by competent and substantial evidence.
Why doesn't Dorton apply here?
Dorton, as cited by the appellant, is distinguishable. And the appellees argue that the court's analysis in Dorton, in fact, addressed the second prong in the law established in Johnson versus Davis. In Johnson, the Florida Supreme Court created the common law cause of action for nondisclosure of material facts. And primary in the creation of a duty on the part of a seller is the proof of the seller's knowledge. Without first showing any knowledge, the issue of the materiality of the facts known by the seller is not relevant. It must first be shown that there is knowledge. And in Dorton, in fact, the court concluded that the seller knew that the house had a flooding issue. After determining that, the appellate court determined the trial court's error occurred where the court improperly measured the defendant's duty to disclose in terms of the damage caused to the defendant, the seller, by the known condition on the premises. Had the court concluded first there was no knowledge, then the issue of the materiality giving rise to the duty to disclose would not have been relevant. And the appellees would argue...
Well, now, your clients had a lot of good bit of knowledge about the condition of this house, because when they went to buy it, they had a problem and required some corrective measures, did they not?
Correct. Before they purchased the home, a hurricane struck at the same, coincided with the time of the closing. And the closing was postponed while the prior owners did certain repairs that were required by Dr. Karsten, and that included repairing the windows to a watertight condition. So when he closed on the house, he had in all believed that the repairs that he required under the closing agreement were effective and that the windows were watertight, and in fact they were tested. He did not have any significant problems during his ownership of the home, and the evidence showed that he performed routine maintenance that included caulking and painting of the exterior every 3 years. And these facts were all detailed in a lengthy 28-page order issued by the court that included 25 pages, in fact, of his factual findings showing...
That was a good order. Did you draw that order? It was well drafted.
He did that on his own.
I was sort of curious.
Nope, that was all Judge Saul's doing.
Thank you.
And the appellees assert the cases cited in the court's final order, Slider and Spitali, are factually more analogous to the instant case and shed light on the requisite evidentiary requirements necessary to establish the first prong of the analysis, which requires showing that the seller had knowledge when alleging a claim of nondisclosure. In both of those cases, in Slider and Spitali, the court concluded there was insufficient evidence to establish the sellers had any knowledge of facts germane to the transaction, which is the first prong, which was not disclosed to an unsuspecting buyer. Having first concluded no knowledge on the part of the sellers, then the issue of materiality was not relevant, and it was not addressed by the court in either case. In both cases, evidence of knowledge was denied despite those sellers having made prior repairs on the homes to the exact issues that were at issue at trial, without evidence that the sellers were on notice of any problems arising after they performed the repair work that would indicate a recurring or repetitive problem, suggesting that they were on notice of some recurrent issue that they should have disclosed.
So the recurrent leaking that they took care of with what they considered routine maintenance, you think that the trial judge was correct in concluding they were under no duty to disclose?
Yes, I do, and because, as in Slider and Spitali, in fact, the Karstens had the roof replaced in 1993, and it was approximately a year and a half before the home was sold to Dr. Dunn. And during that time period, after the new roof was put on, with the skylights incorporated into the roof, there were no incidences of leaking, nor was there any caulking or painting that occurred. So there was no recurrent or repetitive issue to disclose.
And it's your understanding they were under no duty to disclose the prior problems that they required to be corrected before they purchased the house themselves?
The Karstens were aware that certain issues had been addressed prior to them purchasing the home, and primarily they were aware of the fact that the windows were repaired, and that was what they demanded before buying the house. The other issues were described to them as cosmetic in nature. It was termed shoring up the structure, and the evidence presented at trial first of all showed the Karstens had no knowledge of the prior lawsuit until this case arose, and all of the experts at trial, the evidence at trial was controverted as to the integrity of the structure, and according to the trial court, as the trier of fact, he concluded that the defendant's expert was successful in disputing the plaintiff's expert's claim that the home was not structurally sound. So in fact, the court concluded that there was no structural issue. And in any case, the Karstens were average homeowners and were unaware of such issues without having knowledge of having an engineering background, essentially. In addition to the Karstens having performed routine maintenance and meticulously maintaining their home, the evidence showed Dr. Dunn, after purchasing the home, never performed any maintenance or repair work on the residence. And Dr. Dunn's own testimony confirmed that the home was essentially abandoned after he purchased it, and he shut off the utilities, which the court reasonably concluded only was likely to have accelerated the deterioration of the home and could have led to leaks occurring, and particularly where the home suffered the damage of 2 hurricanes that occurred after Dr. Dunn purchased it in the summer of 1995. All the experts agreed and testified at trial that routine maintenance is imperative for coastal homes, which was not done by Dr. Dunn. Routine maintenance may have effectively arrested the development of any potential water intrusion while the Karstens owned it, and Any potential water intrusion may not have become apparent until the structure was allowed to deteriorate, as the experts testified it clearly had by the time of the trial when Dr. Dunn owned it. As for the structural defects alleged by the appellant, the finder of fact, after weighing the evidence and assessing the credibility of the parties' experts, reasonably concluded, as I stated before, that Mr. Barkley refuted the appellant's expert, Mr. Douglas, after Barkley concluded that the home was structurally sound. And in addition, despite the condition of the home, the experts agreed that structural defects would not be recognized by the average homeowner, by Dr. Carson or Dr. Dunn, by looking at the home. Thus, based on the evidence of record, the trial court, serving as the finder of fact in this case, reasonably concluded that the Carsons did not have any knowledge. And under Slider and Spitali, that is the prerequisite before broaching the issue of materiality and determining whether a duty to disclose arises under Johnson versus Davis. In the alternative, the court concluded it was likely that any water intrusion arose after Dr. Dunn purchased the home and was likely a result of damage incurred from 3 consecutive significant weather occurrences in the summer and fall of 1995, which only worsened as a result of Dr. Dunn's neglect of the residents. In conclusion, the appellees request affirmance of the trial court's final order, in which the lower court reasonably concluded the appellant failed to establish by competent, sufficient evidence the liability requisites set forth in Johnson versus Davis and the evidentiary requirements set forth in Slider and Spitali.
Thank you.
Thank you.
Your Honor, I can't hold you to 19 seconds, so we'll give you a whole minute today.
Your Honors, and I thank you. I think what it really comes down to in this case is that when you look at the totality of the evidence, there's no doubt that the sellers knew of facts which materially affected the value of this house. When you look at all of the cases from the other district courts, the Supreme Court, as well as this one, it's very clear that water leaks, and particularly recurrent water leaks that are only temporary, must be disclosed. And that's what we're dealing with here. It leaked before they bought it. It leaked while they had it. They caulked them. They painted them. But they chose not to disclose. Under Johnson versus Davis and the provisions of the contract in this case, they must disclose. This is what Dorton is.
Davis, real quick, wasn't there some evidence? It's undisputed there was some evidence of a little bit of water damage there in this record, wasn't there?
It's not a little bit, Your Honor. It's quite a bit.
Well, everybody admitted, even the other side, that there were 2 streaks there, right?
Yes, sir.
Okay.
And the multiple caulking and all of that. And there's also the question of the sagging roof and the structural defects which were shored up that they never denied. They knew about. They didn't disclose. Thank you, Your Honors, and I appreciate your patience.
That concludes our cases for the week. Court's adjourned.